Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you'll enjoy this legal education content, and today will be the day I earn your subscription. For yesterday's content, we were discussing the United Airlines vax mandate and a decision by the Fifth Circuit. For today's content, we're going to do a bit of a follow-up on yesterday's decision. One of the commenters in the video yesterday said that I was not paying attention to a United States Supreme Court case called Frazee versus Illinois Department of Employment Security. And I thought, this is a good opportunity for us all to take a look at this and see what difference it might impact on our analysis, right? We can read a different case. We can see what, if anything, it will impact our analysis. So just by way of explanation from yesterday's video, so those of you who want a brief summary, United Airlines imposed a vax mandate, as so many did. Some various employees refused to get the vax mandate, citing religious reasons. United put them on indefinite leave without pay. They didn't fire them. They put them on indefinite leave. They sued seeking an injunction. Well, they sued seeking remedies, obviously, ultimately, and also, more notably, asked for an injunction. So an injunction comes earlier in the case, as we've discussed, like a TRO or a preliminary injunction. It's earlier in the case and is used to do things to fix the situation right now, whereas on the merits, you ultimately decide the whole merits of the case, right? And injunctions are never afforded as a matter of right. That is clear in the case law, right? As opposed to legal remedies, which are afforded as a matter of right because they're legal remedies. So what we're going to do is we're going to read this decision Frazee, which deals with unemployment issues as it relates to people discriminated on the basis of religion. And we will see to what degree, if any, it impacts the legal analysis we did yesterday when it comes to the United Airlines vax mandate. Okay, so let's go ahead and do that. This is a 1989 United States Supreme Court decision, Frazee versus Illinois Department of Employment Security. It's not a very long case, so we'll just read the entire thing. Justice White is delivering the opinion of the court in 1989. The Illinois Unemployment Insurance Act, so the first thing I note right away, which might be a difference that's worthy of noting, right, is that we're dealing with the Illinois Employment Insurance Act as opposed to Title VII. So different laws, and for that matter, promulgated by different sovereigns. One is the state level government of Illinois. Title VII, for example, is promulgated by the United States government, right? So there are different laws promulgated by different sovereigns, so we must at least alert ourselves to the possibility that that fact will drive some of the analysis. So let's, keep that in mind. The Illinois Unemployment Insurance Act provides that an individual shall be ineligible for benefits if he has failed without good cause to either apply for available suitable work when so directed or accept suitable work when offered. William Frazee refused a temporary retail position offered to him by Kelly Services because the job would have required him to work on Sunday. Frazee told Kelly that as a Christian he could not work on the Lord's Day. Frazee then applied to the Illinois Department of Employment Security for unemployment benefits, claiming that there was good cause for his refusal to work on Sunday. His application was denied. Frazee appealed the denial of benefits to the Department of Employment Security Board of Review, which also denied his claim. The Board of Review, again, this is Illinois Board of Review, stated, when a refusal of work is based on religious convictions, the refusal must be based upon some tenets or dogma accepted by the individual of some church, sect, or denomination. And such a refusal based solely on an individual's personal belief is personable and non-compelling and doesn't render the work unsuitable. All right. So it looks like the Illinois Department of Unemployment here is saying that for it to be a religious belief, it has to be seems to be what they're saying. For it to be a religious belief, it has to be a religious belief of some sort of church or sect or otherwise organized group of people. So it has to be a doctrine or dogma or teaching of something that we could describe as a church in some sense. The Illinois Department of Unemployment seems to be saying that if this is merely a personal belief, not one that's necessarily promulgated by any church, that does not qualify as a religious belief. A merely personal belief does not qualify as a religious belief. That seems to be what they're saying, which seems wrong, right? Because a religion can be a religion of one, as long as it's sincerely held. So that seems wrong. But let's read some more. The Board of Review concluded that Frazee had refused an offer of suitable work without good cause. The Circuit Court of the 10th Judicial Circuit of Illinois, still in state law, affirmed, finding the agency's decision was not contrary to law against the manifest weight of the evidence, thereby rejecting the claim on free exercise of the First Amendment. Frazee's free exercise claim was again rejected by the Appellate Court of Illinois, 3rd District, still in state law. The court characterized Frazee's refusal to work as resting on a personal professed religious belief and made it clear that it did not question the sincerity of the plaintiff, which is really good, incidentally. It then engaged in historical discussion of religious prohibitions against work on the Sabbath, and in particular on Sunday. Nonetheless, the court distinguished Schubert versus Vermeer from the United States Supreme Court, Thomas versus Review of Board of Indiana Employment from the U.S. Supreme Court, and Hobbs versus Unemployment Appeals Commission of Florida, also from the United States Supreme Court. So as you might have expected, this kind of issue has come up before the United States Supreme Court multiple different times. You can see it came up at least 3 other times in some other context that could be deemed as somewhat comparable, which is not necessarily unusual. And this case is going to be another one. And so the Illinois courts, in analyzing this case against the precedent, said this case was distinguishable against all these precedents. Okay. Why do they say it's distinguishable? Well, the reason they say it's distinguishable is because, unlike the claimants in those prior cases, Frazee was not a member of an established sect or church, nor did he claim that his refusal to work resulted from a tenet, belief, or teaching of an established religious body. So that's why they're distinguishing it, right? It's the Illinois courts when they're analyzing it. They say, hey, these other U.S. Supreme Court cases all deal with teachings of something that could be viewed as a church in some sense. Frazee is not a member of a church. He's not saying that this is a teaching of a church. For him, it's not. It's a personal conviction. So the Illinois courts are distinguishing on those grounds. Okay. Frazee's position that he was a Christian, and as such felt it wrong to work on the Sunday, was not enough. That was the Illinois court's position. To the Illinois courts, Frazee's position that he was a Christian and as such felt it wrong to work on Sunday was not enough. The Illinois court continues. For a free exercise claim to succeed, said the Illinois Appellate Court, State Court, the injunction against Sunday labor must be found in a tenet or dogma of some sort of church. Frazee does not profess to be a member of any such church. And the Illinois Supreme Court denied leave to appeal, which I'm interpreting as a leave for certiorari, which I'm guessing they call something different in Illinois. So the Illinois Supreme Court denied to hear the case. All right. The mandatory appellate jurisdiction of this court was invoked under 28 U.S.C. 1257-2, since a state court rejected a challenge to the constitutionality of Illinois' statutory good cause requirement as applied in this case. We noted probable jurisdiction now reversed. So apparently, in this kind of situation, under the relevant law in the United States, and I don't know exactly why, because I'm not familiar with this, and I guess we could look it up. Maybe we'll do that after the case to find out why the court has to hear this case. Just as an aside, why does the U.S. Supreme Court have to hear this case? Apparently there's a statute on point, and so we can go read it, and we'll learn something. But we'll do that afterwards, figure out why the court has to hear this case. At the moment, it doesn't matter. They heard the case, and we're interested in their decision, right? The procedural aspect we'll get back to. All right, so now the Supreme Court has decided to hear the case, or must hear the case. What do they say? We have on more than one occasion before today to consider denials of unemployment compensation benefit to those who have refused to work on the basis of religious beliefs. In Sherbert, the court held that a state could not constitutionally apply eligibility provisions of unemployment compensation program so as to constrain a worker to abandon religious conviction respecting day of rest. Under Thompson versus Review Board of Indiana, we also held, this is now the Supreme Court talking, we've also held states' refusal to award unemployment benefit compensation to one who terminated his job because his religious belief forbade participation in the production of armaments, which would be, in this case, weapons, violated the First Amendment right to freedom of exercise. Just 2 years ago, in Hobby versus Unemployment, this is 1989, 2 years ago, so they're saying 1987, in Hobby, Florida's denial of unemployment compensation benefits to an employee discharged for her refusal to work on the Sabbath because of religious convictions adopted subsequent to employment were also declared to be a violation of free exercise clause. So in that particular case, it wasn't a belief of the employee when they started working, but it became a religious belief. So that was the basis of distinguishing that case, or attempting to distinguish. It wasn't a belief at the time of employment. It's a new belief. And so maybe that's a fact that changes the analysis. It didn't, but it was a different fact pattern. In each of these cases, applicant was forced to choose between fidelity of religious belief and employment. And we found the forfeiture of unemployment benefits to choosing the former over the latter brings unlawful coercion to bear on the employee's choice. In each of these cases, we concluded that denial of unemployment compensation benefits violated free exercise clause of First Amendment on Constitution, as applies to states throughout the 14th Amendment. Okay, so one big distinguishment we can make right away as relates to United Airlines is I don't know the degree to which the United Airline employees who have refused to get the vaccine and have been put on indefinite leave, I don't know the degree to which they've applied for unemployment benefits under the relevant state law. And I don't know the degree to which they've been denied unemployment benefits under the relevant state law. I know that they were suspended, or they've been suspended without pay by United. But whether or not they're eligible for unemployment benefits, I don't know, right? United would presumably argue that they were fired for cause. And if they were seeking unemployment benefits, United employees could cite this case, among others, as the proposition that no, it really wasn't without cause. It was for good cause. And therefore, they're still eligible for unemployment, which maybe they are. I don't know if they're eligible for unemployment or not. This case would tend to suggest, yes, they are eligible for unemployment, but that wasn't the issue we were trying to solve in the case with United. We were trying to solve a request for an injunction under Title VII, which deals with whether or not the employer is wrong to discriminate against them. Unemployment is given by the state, which is one of the reasons we're talking about a free exercise challenge. We talked about this distinction also yesterday in the case with United, because one of the things the Fifth Circuit was doing was talking also and trying to reason by analogy, although I thought ultimately unsuccessful, to cases where the government is the one being sued, and talk about coercion relating to free exercise by the government, which is an injury by the government because the government is subject to the First Amendment. Right? But in the case of United, United is a private actor. And despite what chat was trying to say yesterday, yes, United is a private actor. They're a private employee. They're a heavily regulated industry. But that doesn't make them not a private employer. They are a private employer. The reason you know that is because their employees are not government employees. Their CEO is not appointed by the president or working for some sort of agency. The CEO is not a government employee, nor is anyone else. United is, in fact, a private company, heavily regulated private company, a publicly traded company, but a private employer because they are not a government actor in their employment. They are not, the government is not a government airline. So free exercise challenges seem a little bit off point to my mind. The Fifth Circuit seemed to disagree, although I thought the dissent was better for this reason. because free exercise challenges deal with governmental action. If you want to talk about private action, the First Amendment is not your go-to. But here, in this case, and presumably if the United employees were seeking unemployment, then we would be talking about government action. So if their respective states were denying them unemployment on the basis of them being fired for cause, then they could bring a free exercise challenge for the denial of those benefits. But that would be a lawsuit against the unemployment agency. It wouldn't be a lawsuit against United. Different entity, different lawsuit. So that's one big issue we can distinguish right away. Continuing on with what the United States Supreme Court said in Frazee. It is true, as Illinois courts have noted, that each of the claimants in those cases was a member of a particular religious sect, but none of the decisions turned on that consideration or of any tenet of the sect involved that forbade work the claimant refused to perform. Our judgment in those cases rested on the fact that each of those claimants had a sincere religious belief that required him or her to refrain from the work in question. Never did we suggest that unless a claimant belongs to a sect which forbids what job requires, his belief, however sincere, must be deemed purely personal preference rather than religious. Which makes perfect logical sense. A religious belief can be a religion of one. It doesn't make it any less a religious belief. That makes logical sense to me. Indeed, as in Thomas, a prior case, there was disagreement among sect members as to whether their religion made it sinful to work in an armaments factory, one that produces weapons. But we consider this to be an irrelevant issue, which of course it has to be, right? Because whether or not the court cannot get into issues of doctrinal beliefs of churches, right? You can't get into that issue. So does the church actually believe it or not? Can the court adjudicate that issue? Hell no. Hell no. So yeah, of course the court is going to say, yeah, it's irrelevant to us. Yeah. But we consider this to be irrelevant and hence rejected the state's submission that unless the religion involved formally forbids work of armaments, the belief does not qualify as religious. Yeah, that would, among other things, require us to get into ecclesiastical matters, and that's just a big red X. Yeah. Because Thomas unquestionably had a sincere belief, his religion prevented him from doing this work. He was entitled to invoke protection of free exercise clause. Makes sense to me. There's no doubt that only beliefs rooted in religion are protected by the free exercise clause. Right. Because it has to be a religious belief in order to be the free exercise of religion. It's right in the title, right? For it to be a free exercise of religion, it has to be a religious belief. Now, I will take note here, and they say purely secular views do not suffice. Now, I will take note here that this can be distinguished on some grounds from other cases where purely secular beliefs can, in some sense, suffice. Because freedom of religion means also freedom from religion. Because one's personal religious beliefs could be in some sense against every other religious belief. That would be the nature of freedom of religion. So there is some cases dealing with things that might be said to be a secular belief, even from atheists. And you can see this in some case law where it says that kind of thing should be treated as equivalent to a religious belief. So this case is saying purely secular views do not, going back to a 1972 case. I don't know, incidentally, whether or not any of those cases that dealt with the religious beliefs, for lack of a better description, of atheists were prior to 1972, but I can tell you there is case law that distinguishes now, and so a purely secular belief might be sufficient in some cases for a free exercise clause. So this line from the U.S. Supreme Court is at best out of date. Assuming it was literally true when written, it is not literally true now. But, you're going to have to be careful, obviously, on that. It's just not every secular belief is going to qualify. I'm just saying that there's some case law that seems to go the other way in some circumstances. That doesn't mean that every personal belief is going to be held to be equivalent to be a religious belief. It definitely doesn't mean that. So, don't go and just apply it willy-nilly, is what I'm saying. Okay, continuing on with what the Supreme Court said in 1989. Nor do we underestimate the difficulty of distinguishing between religious and secular convictions and in determining whether professed belief is sincerely held. States are, now that is one thing that you can get into as a court, right? You can't get into whether or not the belief is true, but you can get into whether or not they actually believe it, right? Whether or not they're claiming it, because if they don't really believe it, it's a fraud. So you can't get into whether or not the belief is reasonable. You can't get into whether or not the belief is true, but you can get into whether or not they actually believe it. That is a thing courts can get into. So if, like you say, well, it's against my religion, a court could at least theoretically say, no, that's not actually a religious belief of yours, you're lying. That is a thing they could do. They can't question the legitimacy of the belief itself, but they can question whether or not you actually believe it. That is a thing courts can do. States are clearly entitled to assure themselves there is an ample predicate for involving free exercise, to make sure that, you actually believe it, for examples. We do not face problems about sincerity or about religious nature of Frazee's conviction, so that's not an issue here. The courts below did not question his sincerity, so they're not saying he doesn't really believe it. The lower courts are conceding he really believes it, so that's not an issue here. And the Illinois Appellate Court referred to his refusal to work as a personal and professed religious belief. So that's not the issue, whether or not he really believes it. Frazee asserted he was Christian, but does not claim to be a member of a particular Christian sect. It's also true that there are assorted Christian denominations that do not profess to be compelled by their religion to refuse Sunday work. Fair enough, true, right? But this does not diminish Frazee's protection. Correct, because his belief is his own. Other there are a lot of different Christian churches, man, who believe a lot of different things. Some of them believe working on Sunday is totally fine. Some of them not so much. So, but it's his belief we care about at the moment. Here, Frazee's refusal was based on sincerely held religious belief. Under our cases, he's entitled to invoke that First Amendment protection against a government actor such as the Illinois Unemployment Office is. The state does not appear to defend this aspect of the decision below. In its brief and oral argument, the state conceded the Free Exercise Clause does not demand adherence to a tenets or dogma of an established religious sect. Instead, the state proposes its own test for identifying a religious belief, asserts that Frazee has not met such a test, and asks we affirm on this basis. We decline to address the submission, for as the case comes to us, Frazee's conviction was recognized as religious, but found to be an inadequate reason. So we're not denying it's a religious belief, we're just denying that's an adequate reason, even though we concede it's a religious belief. That's what the courts are This ground for decision, because he did not claim to represent a tenet of a particular religious organization of which he was a member. That ground for decision was clearly erroneous. The state offers no justification for a burden that the denial of benefits places on Frazee's right to exercise religion. The Illinois Appellate Court ascribed great significance to the American weekend way of life. The Illinois Court asks, what would Sunday be today if professional football, basketball, baseball, and tennis were barred? Today, Sunday is not only a day for religion, but for recreation and labor. Today, supermarkets are open, service stations dispense fuel, utilities continue to serve the people, and factories continue to belch smoke and tangible products, concluding that if all Americans were able to abstain from working on Sunday, chaos would result. We are unpersuaded, however, there will be a mass movement away from Sunday employ if William Frazee succeeds in his claim. I guess everyone could claim that would be a religious belief of theirs, but if it was truly a religious belief of everybody, then society would reorganize accordingly just by kind of natural operation, right? If everyone said working on Sundays against my beliefs, whether it's religious or not, society would obviously reconfigure itself and work wouldn't happen on Sunday. Society would obviously adjust to this new reality because that's collectively the belief of society. So first of all, we don't think it's going to happen. Second of all, even if it did, society has lots of beliefs. Those beliefs in many different domains burden lots of things, including commerce. And if those beliefs cease to exist, then commerce would change. And if things, that's fine. So it's like not even a problem. As was the case in Thomas, when there was no evidence in the record to indicate the number of people who find themselves in the predicament of choosing between benefits and religious belief is large enough to create widespread unemployment or even seriously affect unemployment. There's nothing before us in this case to suggest that Sunday shopping, or Sunday sporting for that matter, will grind to a halt as a result of our decision today. As we said in the past, there exists state interest sufficiently compelling to override a legitimate claim to the free exercise clause of religion. We've discussed this before, for example, in the Smith case, right? Where we've discussed how you can treat religion the same, but not worse than other components, right? So we've discussed this. As long as you're treating, as a general proposition, as long as you're treating religion the same as secular counterparts, a free exercise claim will not work as a general proposition. So yeah, that's Smith. We know that. But no such interest is present here. And so the judgment is affirmed. Okay. So yeah, so all that. All right, so now I promised at the end of this that we'd go look at this procedural aspect, because I'm interested to know why the U.S. Supreme Court has mandatory jurisdiction. So let's go look at this aspect and see what it says in terms of jurisdiction of the Supreme Court and why the Supreme Court has to hear this case, apparently. All right, so let's take a look at this real fast. (57) sub 2. There is no 57 sub 2. Hold on. I need to figure out 28 USC 1257 sub 2. 28 USC 1257. There is no sub 2. Did the law change? Maybe there was a previous version or something. That would make sense, incidentally, if that's true. Because there was a lot of reform, incidentally, where the U.S. Supreme Court had to hear a whole bunch of cases mandatorily, and then the United States Congress took a whole bunch of that away. So it made total sense that this is no longer a thing, and this is old law. So let's take a look at, because I think 1988, let's take a look at let's see. So this is A and B. There's still no sub 2 in 1988. Maybe it wasn't in effect yet. Or it wasn't the law at the time. Maybe that's the issue. Let's go to the law before that. Let's go to the law from 1970. Give me a second while I look this up. Because I'm interested and, I want to figure this out. But it would make total sense if that's what's going on. And then we'll do some analysis of it. That's the wrong law. That's the wrong law. That's the wrong one. It was repealed 90 days after June the 27th, 1988, so I'm betting it was just not in effect at the time of the relevant law. '57. This is 1988 Act. I need the act from before that. One moment, please. I know that these moments of silence are a little bit tedious, but, it's like when something's interesting, I want to do some legal analysis. It takes a minute to pull the relevant stuff and figure out what's going on. So I apologize for the slight tedium as I, actually look up things. Okay, so I need 1257. Let's see, criminal procedure, section 22, conduction of prosecutions, extradition, professional bondsman. 84 statute 590. Am I in the right place? 84 statute 590. I don't see it on page 590. I am sorry that I'm having such trouble getting this. This is 1988 again. I don't need the 1988 thing. All right, let's take a look at public law. 1948. (1970). 48 stat. Okay. Section 151 deals with title, changes to title. All right, so I need, hold on. I'm poking around in actual bills passed by Congress now to try to find the language. This is not really good telly, as they say, though, with all this pausing. But I'm committed now, so... It's in here somewhere. I just have to find the relevant section. Amendments to District of Columbia Code. That's not what we want. Amendments to other laws. Transition portions, criminal law procedure. Public defenders, interstate compact on juveniles. Reorganization of courts. Okay, I can't find it right now. I'm going to stop looking because I can't find it. But I'm just going to assume that that's what happened. I'm going to assume that the old law, because they're citing this thing, subsection 2, which doesn't exist. I'm going to assume the old law required the U.S. Supreme Court to do this. And at some point, 1988, they apparently changed it. I'm just having trouble finding the exact language of the law as existed before. Apologize for that to the chat and everyone else. All right, so now that I've stumbled around and wasted time trying to find something, I wasn't quite able to find it fast enough. So does this change the analysis from yesterday? And the answer to that question is no. It doesn't change the analysis from yesterday. The reason is, of course, multifold. First of all, in the case of Frazee, they're suing the unemployment office, which is a government actor, which means that we have free exercise concerns because we have Title I concerns. And so all that issues, right? So, or First Amendment concerns. I think it's a Title I concerns. Yeah, so does that analysis apply to United? No, United is not a governmental actor. They're a private actor. They are a heavily regulated industry, but they're a private actor. All their employees are private. They're not governmental employees. They're paid privately out of private money, and so forth and so on. So they're a private actor, not a governmental actor. So all the First Amendment analysis doesn't apply at all to this in terms of this. So yeah, it doesn't really impact the analysis from Frazee. Frazee doesn't really impact the analysis for yesterday. Second of all, even if it did somehow impact the analysis, it would be a merits issue, not necessarily an injunction issue. Because it would go to likelihood of success, for example, but not necessarily the irreparable harm, which, as we discussed yesterday, was more based on money. So, yeah. So I don't really think this case impacts the analysis from yesterday at all. Is what I kind of think. Asteroth says, welcome to the reason why average citizens hates laws. Even lawyer can't easily look up things that can utterly ruin someone's life on a gotcha. As I was trying to look up old law, Azeroth, I found the current law easy peasy. I was trying to find the law that existed in 1987, and I couldn't quite pull it up fast enough in terms of trying to find the laws that existed in 1987. So if you're concerned about if you're concerned about your conduct today as a citizen, then the law from 1987 probably isn't that important to you. I was just interested on a historical note about the jurisdictional thing. So yeah, I could find it. I just was unable to find it fast enough. And I was just curious out of a purely academic point of, oh, I bet I know the reason. And I just wonder what the old language used to say. So it's like, yeah, I don't think it's as much a problem as you seem to say. King of Casual says, you said they're not eligible for unemployment. I didn't actually, strictly speaking, say that. I simply said that they might be because it could be deemed as a for-cause firing. I don't think I ever said flatly they were ineligible for unemployment. I simply noted the issue in my stream yesterday. I noted the issue by saying, okay, look, there might be a problem with unemployment because United might say it's for cause, which might prevent them from getting unemployment. So all that's true, right? It's noting the issue. It's like, yeah, they might have a problem getting unemployment benefits because United might say it's for cause for failure to get the vaccine. And if it's for cause, you can't get unemployment. Right. And then, of course, this case would say, but wait a second, you can get unemployment. But that's the count. But I was just noting the issue. I wasn't saying they couldn't. I was just saying here's a problem that might exist, right? So yeah, I think people take things I say and read them more absolutely than I really intend to say them. Caroline says, concur with private versus government actor analysis. Also concur with the injunction analysis. Seems United plans could have planned tactics better. Now they're down the wrong rabbit hole. Yeah, I mean, I tend to agree. ST Seeb says, when are beliefs considered religious? I suppose when the person themselves consider them to be religious. If you consider them to be religion, then they're religious. Then yeah, then that would be it. Yeah, if it's a truly held religious belief, if you believe it's religiously required. So I mean, it's kind of, yeah, I mean, it doesn't require much more than that. And that's all the questions I see for now. Azeroth said, my point is, even politicians will cite old outdated law like it hasn't changed. Well, politicians suck. If they're citing outdated law, then, I mean, you know, it's like, okay, but it's outdated, so it doesn't matter. Yeah, so I don't think this analysis changes anything I said yesterday. It definitely doesn't change the injunction standard. All this stuff is dealing with free exercise clause as it relates to a governmental actor, namely the Illinois unemployment offices. Title VII doesn't deal with free exercise. At least it doesn't in this context because it's not a governmental actor. So free exercise clause is out the window, at least to me. And so all that stuff. So yeah, so that's kind of legal analysis. So I hope this was in some way helpful, or some way informative, or some way enjoyable as we conducted a little bit of analysis on Frazee and see to what extent, if any, it impacted the analysis. So, you know, after all that, I just go ahead and disagree with the commenter from yesterday. I don't think that this case impacts the analysis, or at least shouldn't impact the analysis from yesterday for all the reasons I just said. So that's snarky thought. Would soft magical spells be considered religious? If they consider them to be religious, maybe. But even then, right? Even then, it wouldn't really work because we discussed this, right? For Smith, if you're treating religion, if you're treating the religions the same as everyone else, Smith applies. So even if the sovereign citizen's beliefs are religious, and the court is saying, you know, I have jurisdiction over you, and they're saying, you don't because of my religion, the court would say, well, religion or not, I have jurisdiction over you. So I'm treating you exactly the same as someone who doesn't have those religious beliefs. So it wouldn't work. And even if it could somehow work, you would be able to get to strict scrutiny because it's a compelling governmental interest and it would be the least restrictive means. I mean, in that circumstance, you could get to strict scrutiny. So I don't see the problem. But, all that stuff. Anyways, if you've enjoyed the stream, please remember to give it a like, comment, subscribe, all the YouTubey things. I'm out for now. We'll be on later with some more stuff, I'm sure. Until later, my friends, I hope all is well. Cheers and goodbye.